Hello everyone, this video is about the Arbitration and Conciliation Act 1996. In this video, we will be starting from section 9. The basics of arbitration and sections 1 to 8 are uploaded in a previous video. I will give the link of the video in description. If you want to watch that, you can go and watch. Please watch the previous video before watching this video. Then only you can get full understanding of the Arbitration Act. Now, let's get into the topic. Let's start with section 9. Section 9 is about interim measures. In the previous video, we saw that it is one of the three special sections where part 1 will also apply when the seat of arbitration is outside India. Generally, part 1 will apply only when the seat of arbitration is in India. But there are three special sections, one of which is section 9. It will also apply even when the seat is outside India. Now let's get into the topic. Interim measures for appointment of guardian for minor or unsound person. First of all, what is an interim measure? In an arbitral institution or arbitration, we will get an arbitral award. In that, there are two types of arbitral awards. One is final arbitral award and the other one is interim arbitral award. Final is the final decision after all the hearings are done. It is the final outcome of the arbitration. And interim award, it is done before the final award. It is given to facilitate the case or to preserve the subject matter or certain things which have to be done before the final award. For those things, we are giving an interim award. In section 9, the interim award will be given by court. Let us see an example to understand the interim measures in a deeper manner. For example, we can assume there is a contract between two persons, Ayush who is a seller and Bharat who is a buyer. The seller is selling electronic goods to Bharat and Bharat has to make payment for it. Bharat receives the electronic goods but does not make payment. What the reason he is telling is that the goods are defective, so I will not make payment to you. Like that Bharat is saying. He is saying that the goods are damaged. Ayush is saying that the goods are not damaged and you have to make the payment. Now this dispute is submitted to arbitration. If this is a dispute in a legal relationship or contractual relationship, so they are going to arbitration. Now in arbitration, Ayush, the seller, fears that the buyer may damage the goods before arbitration. Before going to arbitration, now the goods is in the custody of Bharat. If he destroys the goods, then it is a loss for the Ayush. So Ayush is fearing that he might damage the goods. So he has to protect the goods. He cannot go and protect the goods which is in Bharat's custody, buyer's custody. Now he have to go to court and request an interim measure under section 9. This is the usefulness of the interim measure. Before going to arbitration, you can get certain orders from the court for facilitating the case. Now Ayush, the seller, goes to court and asks for preservation of goods. The seller asks the court to give an order that the buyer should protect the goods and preserve it before the arbitration starts. Before arbitration starts, he cannot sell off or destroy the goods. And freezing the bank account of Bharat. Buyer, if he does not have any money, the seller cannot recover any money. So, in order to secure the amount from Bharat, he has to get an order from the court to freeze the bank account. If the bank account is freezed, then no one can take the amount, and if the arbitration comes in favor of the seller, he can recover the amount from Bharat, the buyer. And he can also request a security deposit. For example, if the payment due is rupees 50 lakhs and the dispute is submitted to arbitration, they can ask the buyer, Bharat, to make a deposit. He has to make a deposit of rupees 50 lakhs in the court. If the arbitration comes in favor of Ayush, the amount will be going to seller, Ayush. If the arbitration comes in favor of Bharat, the buyer, then the 50 lakh will be returned to buyer. This is the case for interim measures. This 50 lakh security deposit is a measure which will help to run the case effectively. If you do not make the security deposit, there is an uncertainty that whether the buyer will pay the amount or not. Now when the amount is deposited to the court, if the arbitration comes in favor of seller, nobody can stop the amount from going to seller. This is the topic of interim measures. Now we can see the definition which is given in law. This is the definition given under law. Interim measures can be used for appointment of guardian or for minor or unsound person. For example, in an arbitration, if one of the parties is a minor or an unsound person, he cannot manage the affairs himself. So we need to appoint a guardian for managing his assets, or the arbitration he has to manage by himself, the guardian. The interim measure can also be requested for preservation of the subject matter. Like in the example we saw, for preserving the electronic goods, the seller got an order from a court. Like that you can get an order from court. Securing an amount in a dispute. Like that in the same example, we got a security deposit of rupees 50 lakhs. That is the meaning for securing the amount in a dispute. We have a dispute, for getting the amount, we are getting a deposit and securing the amount. If the arbitration comes in favor of the seller, the amount is very certainly it will be given to the seller. detention, preservation or inspection of documents. For example, if there are documents related to arbitration and any party may damage it or destroy it, you can have a order from the court for inspection and preservation of the documents, appointing a receiver. This is also an order which can be received from court by using section 9. If the court passes an interim order, arbitral proceedings shall be commenced within a period of 90 days of such an order. We have a dispute, and for that dispute we are going to arbitration. Before the arbitration we are getting the interim measure. After getting the interim measure we cannot wait for a very longer period, because the subject matter will be being preserved, the amount will be deposited, and the buyer cannot wait for a long period to get back the amount. So we have to start the arbitral proceedings quickly after getting the interim measures. The period of the time limit is 90 days. After getting the interim measure, within 90 days we have to start the arbitral proceedings. The next point is, once the arbitral tribunal is appointed, court cannot entertain application under section 9(1). Before going to arbitration, we can get interim measure from court. But once the arbitral tribunal, the arbitrator is appointed, now you can get whatever the interim measure you want, you can get it from the arbitrator. You need not go to court. We got to court in the first case because there was no arbitrator appointed and the arbitration has not started. Once the arbitral tribunal is appointed, you can go to arbitrator, unless the court finds that the remedy under section 17 may not be effective. For example, the court gave an order for preservation of electronic goods in the above example. This is an order given by court. If the same order has to be given by tribunal, it will be given under section 17. This interim measure section 9 is for courts. Court can give interim measure under this section. For tribunal, arbitral tribunal to give the interim measure, it should give under section 17. So this is the section for tribunal. If the tribunal cannot give, or if the remedy under section 17 given by the tribunal is not effective, then court can take up the matter under section 9 and it can give interim measure. Otherwise, generally, arbitral tribunal should give the interim measures once it is appointed. The important point in this section is, for these measures we can get an order from the court, and after the order within 90 days the arbitral proceedings should be started. But after the arbitrator is appointed, we cannot go to court under section 9. The next section is section 10, number of arbitrators. These are all the sections which we will be seeing later, which will be under arbitral tribunal section. This will all be about the arbitral tribunal, the composition, the number of arbitrators, etc. Section 10, number of arbitrators. Parties are free to decide, but it cannot be an even number. In this case, the parties can appoint the arbitrator themselves, whether it be 11 arbitrators or 13 arbitrators. If you want 3 arbitrators, or if you want a single arbitrator, you can also appoint a single arbitrator, but it cannot be an even number. The problem is that if you appoint 4 people as arbitrators, 2 people will be in favor of party 1. 2 people will take decision in favor of party 2. Now who will take the final decision? It will end up in a tie, and we cannot solve the problem easily. So we have to appoint an odd number of arbitrators. In case of odd number of arbitrators, 2 persons will be in favor of party 1, 1 person will be in favor of party 2. In this, the majority decision will be prevailing. We can take the decision of majority and give it as an arbitral award. So we have to appoint the number of arbitrators only as an odd number. Then procedure for appointment of arbitrators. Empowers court to designate arbitral institutions which are graded by ACI. If you want to appoint arbitral institution, you can go to court and you can make an application to the court. We want an arbitrator. The court will designate arbitral institutions which are graded by ACI. They will give you certain arbitral institution. These are all the arbitral institution. You can choose from this. Like that, they will give a list, or they itself will give you this arbitral institution will take up your case. Like that, the court will designate the institutions for you. For appointment of arbitrator, in case of domestic arbitration, if you want an arbitrator, you have to go to High Court and get an order. In case of international commercial arbitration, if you want to appoint an arbitrator, you have to go to Supreme Court. You have to go to court, you have to make an application, and then they will specify or designate arbitral institutions to you. And they will appoint an arbitrator and see the administrative work for your case. Now we can see the subsections of section 11. Section 11, subsection 1, nationality. Any nationality unless otherwise agreed. The arbitrator you are appointing, right, whether it should be Indian, or it should be a United States citizen, or it should be a England citizen, like that, the nationality of the arbitrator is the question here. Any nationality of arbitrator can be appointed unless otherwise agreed. For example, in your arbitration agreement, it is written that the arbitrator should be a US citizen or a US national. He should be an arbitrator. Then in that case, you cannot appoint an arbitrator of Indian origin. You have to go by the agreement. If there is no such agreement, then you can appoint any nationality like you want. Procedure for appointment as decided by the parties. In the arbitration agreement itself, you have to decide by what procedure you will appoint the arbitrator, how you will select the arbitrator, which arbitral institution you can go. Like that, there is a procedure which will be decided by the parties mutually when preparing the arbitration agreement. The main point is arbitration agreement. Everything will be specified in it. If something is given in arbitration agreement, you have to follow it. You cannot go against it. The next point is in case of 3 arbitrators. Each party will appoint 1 arbitrator and the third arbitrator will be appointed by the 2 arbitrators already appointed. Let us see an example to understand this point. For example, in an arbitration there are 2 parties, party 1 and party 2. In case of if you want 3 arbitrators to be appointed in the dispute, party 1 will appoint A1, one arbitrator will be appointed by party 1 and one party will appoint 1 arbitrator. The second party will appoint 1 more arbitrator. Totally now there are 2 arbitrators. For the third arbitrator, who will appoint it, party 1 or party 2, both of them will not appoint. The already selected arbitrators A1 and A2, they will jointly appoint arbitrator 3. This is the case in case of 3 arbitrators. First arbitrator appointed by one party, second one appointed by another party, third one will be appointed by the 2 arbitrators already selected. This is given under section 11. Next point under section 11 is subsection 3A, arbitral institutions. Courts have power to designate arbitral institution. If you go to court and ask for an arbitrator, the court can designate arbitral institutions to take up your case. This is given under section 3A. Appointment of arbitrator by arbitral institution in case parties fail to appoint arbitrator. If a party fails to appoint an arbitrator within 30 days of request from other party. We have an example for understanding this. Let us go to the example. In this example, there are 2 parties, party 1 and party 2. Party 1 is sending a request to party 2. They got a dispute and they are going to solve to arbitration. Party 1 is sending a request letter to party 2 to appoint the arbitrator. He is giving the work for appointing arbitrator to party 2. Party 2, he has to appoint the arbitrator, but he does not appoint within 30 days of request. In this case, the arbitrator is not appointed. And there is another case also. There are in case of 3 arbitrators, we already saw that the third arbitrator will be appointed by the already selected 2 arbitrators. For example, in the same example, we can assume that party 1 appointed an arbitrator, party 2 also appointed an arbitrator, but these 2 people should together appoint a third arbitrator. That third arbitrator is not appointed within 30 days. 30 days is the time limit. Whether the parties are appointing or the arbitrators are appointing within 30 days, if they do not appoint, then 11 subsection 4 will apply. Now let us see what is given under the section text. In the section text, it is given that if a party fails to appoint an arbitrator within 30 days or 2 arbitrators fail to appoint a third arbitrator within 30 days, what will happen is that the appointment shall be made by arbitral institution designated by court on an application by a party to the arbitration. On an application by party. Now let us understand what this is saying. If the arbitrator is not appointed within 30 days, either by the parties or by the first and second arbitrators, what will happen is a party to the arbitration can make an application to the court. Now what the court will do is that court will designate an arbitral institution. Court will be saying that party, you cannot appoint the arbitrator because you are not allowed to appoint after 30 days. You are coming to us for an arbitrator. Now we are designating an arbitral institution like the International Chamber of Commerce to take up your case. The arbitral institution will appoint an arbitrator for you. You don't need to search for arbitrators. The arbitral institution will also appoint within 30 days. Court will order the arbitral institution and the institution will appoint the arbitrator within 30 days. This is the procedure. This is the procedure given under section 11 subsection 4. This is an important section and all the appointment under section 11 will be made under section 11 subsection 4. We will be studying it later. This is the procedure for appointment given under section 11 subsection 4. Subsection 5, what it is telling is that appointment of arbitrator by arbitral institution in case parties fail to appoint sole arbitrator. Single arbitrator also parties are unable to appoint. They did not appoint within 30 days. Appointment shall be done in accordance with subsection 4. The procedure we saw will apply. And subsection 6, appointment of arbitrator by arbitral institution in case parties fail to follow agreed procedure. I already told that there will be an arbitration agreement and in that there will be everything about the arbitration, including the procedure to appoint the arbitrator. The parties already decided a procedure and wrote that in the arbitration agreement. If that procedure is being followed and any one party fails to act by the procedure or the parties for 2 arbitrators fail to reach an agreement under the procedure, or a person fails to perform work entrusted under the procedure. First thing is any one party is not following the procedure. then also this will not, you cannot appoint an arbitrator properly. The parties or two arbitrators already appointed, they cannot follow the procedure and select an arbitrator. There is a problem in selecting arbitrator under the procedure. A person fails to perform work entrusted under procedure. For example, in a procedure, there are two parties, party 1 and party 2. There is one work which is given to party 1 and one work which is given to party 2. If they two do their work properly, then we can follow the procedure and we can appoint an arbitrator properly. In case party 1 does not follow the procedure and does not do the work entrusted to him, then what we can do? Then this also comes under section 11 subsection 6. In these cases, what will be done is appointment shall be made by arbitral institution designated by court. Same, section 11 subsection 4 procedure will apply. The party will go apply to the court will designate an arbitral institution and the arbitral institution will appoint an arbitrator. Then section 11 subsection 6a is omitted. Subsection 6b, what it tells is that designation of arbitral institution not to be regarded as delegation of judicial power. The court, what it is doing, that it is simply appointing an arbitral institution. It is not delegating any of its judicial powers. Under a constitution, a court cannot give any of its powers, which is called delegation of powers. There are certain powers which is given to court, and court cannot outsource it to anybody and tell them to do the work of court. This is not possible under the constitution. So the court will appoint an arbitral institution just to take up the case, not giving any of the judicial power to the arbitral institution. It is just appointing to take up the case. Subsection 7 is omitted, and subsection 8, disclosure regarding independence and impartiality from the arbitrator. We already saw that the arbitrator should be very independent and impartial. He should not be should not show partiality for any party. Arbitral institution, before appointing an arbitrator, shall seek a disclosure from him in terms of section 12 subsection 1. Under section 12 subsection 1, we will study what are the disclosures to be given before being appointed as an arbitrator. For example, you are being appointed as an arbitrator. You have to give certain disclosures and sign it, and you have to give it to the parties before being appointed as an arbitrator. Like it is an agreement to be an arbitrator, like that. You will be given a disclosure that you should fill it and give it. The qualification as agreed by the parties contends that he is independent and impartial. In that declaration what you are giving, it should have the qualification agreed by the parties. For example, in an arbitration agreement, it is written that the arbitrator should be a chartered accountant. Now, if you are appointed as an arbitrator, you have to give the declaration that I fulfill the qualification. I am a chartered accountant and I can be an arbitrator as per the agreement. And you have to also include that I am independent and impartial. This is the thing given under subsection 8. Subsection 9 is in case of appointment of sole or third arbitrator in an international commercial arbitration. In an international commercial arbitration, where at least one party is from outside India, the arbitral institution may appoint the arbitrator in a different nationality than the parties. For example, there is one party who is from USA and there is another party who is from India. Now the arbitrator, whether he should be a United States person national or whether he should be an Indian, this is a problem. For example, if the arbitrator is appointed as a USA person, it will be in favor of USA person. If the arbitrator appointed is Indian, he will go in favor of the Indian person. Now this is a problem. So we have to appoint an arbitrator in a different nationality than the other parties. Now you can appoint an arbitrator as an Australian. This will not cause any problem. He will be impartial and independent, and he will be a center, and he will not go in favor of any party. The next point is subsection 10, which is omitted. Subsection 11, request to too many arbitral institutions. The arbitral institution to which the request has been first competent to appoint. For example, you give request to different arbitral institutions. You give to International Chamber of Commerce. You are giving to a law firm. Like that, you are giving many requests to many arbitral institutions. Now, which arbitral institutions will appoint the arbitrator? The first arbitral institution to which you gave the request, and along with the request, it should also be competent to appoint. It should be an arbitral institution recognized by the ACI. Competency means Arbitral Council of India. This will recognize the arbitral institutions. If the arbitral institution is recognized and you also gave a request, the first arbitral institution which has both of these will be competent to appoint. Then subsection 13, application for appointment under this section must be disposed of within 30 days. The process we saw, right? You are a party, you will go to court will designate an arbitral institution, and the arbitral institution will appoint an arbitrator. This should be happening within 30 days. Fees determined by arbitral institution subject to rates specified in the 4th schedule. The arbitral institution is appointing an arbitrator for you. It is doing a service. you have to give fees to that. They are also having a very big structure, they also have expenses. For getting that, they are appointing an arbitrator and charging fees from you. The arbitral institution can charge fees from you, but it is subject to the rate specified in the 4th schedule. We saw that there are sections and schedules separately. In schedule 4, it is given that there is fees to the arbitral institution. You can get fees from the parties, but subject to schedule 4 rates. There will be maximum fees, only this much you can get. You can get minimum fees of this much, like that. Those rules should be complied. Those rules are given under schedule 4. The next section is section 12, grounds to challenge the appointment of arbitrator. Before appointing an arbitrator, you are getting a disclosure. But after appointing an arbitrator, if you want to challenge the appointment, no, this arbitrator is not right, the appointment is not valid. Like that, if you are saying, how to say that, what is the procedure to challenge, on which grounds you can challenge, what is the basis on which you are challenging, that is also given under law. Arbitrator, before appointment, he should give a disclosure. This is the section 12 subsection 1 which we saw already. The disclosure should be in this format. Any past or present relationship or interest in the parties, giving rise to justifiable doubts on independence and impartiality. There are certain relationships. If the arbitrator has any relationship, he is related to the party, he will have an partiality towards that party, so he cannot be appointed as arbitrator. There are certain relationships which is given in the 5th schedule. There are schedules in the 5th schedule, the certain relations are given. For example, father, mother, like that, there will be relations given under 5th schedule. Those relations, if the arbitrator is related to the party by that relation, then it will give a doubt on the impartiality and independence of the arbitrator. So he should give an disclosure that I had this much relationship, or I did not have any relationship with the parties. Like that, he should give a disclosure in writing before appointed as an arbitrator. And the second disclosure is any circumstance likely to affect his ability to devote time and complete the arbitration within 12 months. Generally, the arbitration must be completed within 12 months. Since it is an alternative mechanism and the main problem is quicker solution will be reached here. This is the reason many people choose arbitration. The maximum time limit is 12 months. Within the 12 months, the arbitration should be completed. For example, if you appoint a renowned lawyer, he is a very experienced lawyer, and you appoint him as an arbitrator. He is a very busy lawyer, he is practicing somewhere and there are lots of clients for him. And if he is in that situation, he cannot give time to your arbitration and solve your dispute. Within 12 months, he cannot do it. If such a situation exists, he should give it in the disclosure before being appointed as an arbitrator. First disclosure regarding the relations with the parties. The relation will be given in 5th schedule. Second one is that whether he will be able to devote time for the arbitration and complete it within 12 months. These are the two disclosures under section 12 subsection 1. And the disclosure should be made in a form given in the 6th schedule. The disclosure should be made in a separate format, the format given in 6th schedule. The next thing is section 12 subsection 2. Arbitrator must disclose to parties in writing about the circumstances. He should give the disclosure. An arbitrator may be challenged. You can challenge the arbitrator appointment only if circumstances exist to give justifiable doubts on impartiality. If you have a doubt that he is acting partial towards any party and you have the basis, you have the circumstances as a proof. Now in this case you can go and challenge the appointment. He does not possess the qualification agreed by the parties. Like that we said in the arbitration agreement, if it is given that the arbitrator should be a chartered accountant and the person appointed is not a chartered accountant, you can go and challenge the appointment. That we have agreed that one day a CA should refer our dispute. You are giving it to a non-chartered accountant. Like that you can go and challenge. Only under these two grounds you can challenge the appointment of an arbitrator. A party may challenge an arbitrator only for reasons which he got aware after appointment. In case of appointment of arbitrator, the parties only are going to appoint it mutually. Both of them will discuss and they will appoint. Arbitral institution will also appoint, but in many cases, mutually the parties will be appointing the arbitrator. If you are agreeing to the appointment, and at the time of appointment, you know that there is a relation between party 2 and relation between arbitrator and a party. Now this you know while you are signing for the appointment. Now after the arbitrator is appointed, you cannot challenge by saying that there is a relation between arbitrator and party. You know that there is already a relation. By knowing this also, you are agreeing and appointing him as an arbitrator. Now again you cannot challenge him by reasons for relation between arbitrator and party. This is given under subsection 4. Subsection 5 is not so important, but still I will read it. Notwithstanding any prior agreement to the contrary, any person whose relationship falls under Schedule 7 is ineligible for appointment as arbitrator, provided that the parties subsequent to dispute being arised can waive the applicability of this subsection. There is a schedule called Schedule 7. In that there are certain relationships given. If the arbitrator is any one of the relationship given under Schedule 7 with the parties, then he cannot be appointed as arbitrator. Now, if this is the main point and it is notwithstanding any prior agreement, even the agreement is, even the arbitration agreement allows the relation, the Schedule 7 is not allowing. So the act is superior and you should not follow the arbitration agreement and you should follow Schedule 7 in that case. Notwithstanding the agreement, Schedule 7 relation person should not be appointed as an arbitrator, provided that the parties subsequent to the dispute being arised can waive the applicability of this section. For after the dispute got arised, there are two persons, party 1 and party 2, they got a dispute. They have an agreement and after that they are having a dispute. After the dispute arised, the party can mutually waive this subsection. They can say that we will not follow this section, like that they can say. This is the proviso to this subsection. Let us summarize once again what we studied under section 12. Grounds to challenge an arbitrator. Arbitrator should disclose two things. First one, relationship with the parties. Second one, the time, whether he will be able to devote it or not and complete within 12 months. Then the subsection 2, what it is telling is that the disclosure should be made. Subsection 3, whether if there are doubts on the impartiality and he does not possess the qualification, you can challenge the arbitrator. Subsection 4, a party may challenge an arbitrator only for reasons she got aware after appointment. If you know the reason before appointment itself, then you cannot challenge the arbitrator based on that reason. Subsection 5 is not so important. The next section is section 13, challenge procedure. Now you have decided to challenge the arbitrator. Now which procedure you will follow, that is also given under law. The parties are free to agree on the procedure. While preparing the arbitration agreement itself, you have to write in that what will be the procedure to challenge the arbitrator. Like that you have to write the procedure. Any party who intends to challenge within 15 days after getting aware of the constitution of the tribunal, send a written statement of reasons to challenge the tribunal. For example, a tribunal is appointed. In that there are three persons, person 1, person 2 and person 3. You got aware of the tribunal constitution. You are getting a notice that your dispute has been referred to tribunal. In the tribunal, these persons are the arbitrators. Now you know the tribunal composition. Now if you do not have an agreement with the tribunal, you are not agreeing with the tribunal. You are saying that person 2 is a relation. He is the father of the other party. Now what you have to do? You are have to challenge the arbitrator. For that, after you know that party 2 is person 2 is appointed, within 15 days, you should give a written statement of reason to challenge the tribunal. You have to send a letter in that you have to write the reasons. These are the reasons. For these reasons, I don't want person 2 to be appointed as an arbitrator. And the second is, if the challenge is unsuccessful, arbitral proceedings shall be continued. You are challenging, and if the challenge is unsuccessful, they are telling that the relation is not there or the relation has ended, like that they are telling, then the challenge will be unsuccessful. But the party can make application to set aside the award under section 34. The arbitral tribunal, if the challenge is unsuccessful, if the challenge is unsuccessful, it will continue the proceedings and it will pass an arbitral award. If you don't want the award, you do not agree with the award, you can go to the court and file an application under section 34. This is an application to set aside the award. This award is not proper. You have to set aside the award or cancel the award. Like that, you can go and apply to the court under section 34. Now this is the procedure for challenge. The parties can agree on the procedure. You should send a written statement of reason within 15 days of you got to know that the tribunal is appointed and the challenge is unsuccessful. They will be passing an award and you can give an application of section 34 to set aside the award. The next section is section 14, failure or impossibility to act as an arbitrator. If the mandate or office of arbitrator shall terminate, if he becomes de jure or de facto unable to perform. For example, if the arbitrator is unable to perform, he cannot conduct the arbitration due to law reasons or due to factual reasons. For example, if you are appointing a person as an arbitrator and he robbed a bank, now the police arrested him and he is in a jail. Now you cannot ask him to come and conduct the arbitration. He is by law and by fact he is unable to perform. He cannot conduct the arbitration. Now the office of the arbitrator is terminated. The arbitrator is ended and you have to appoint another arbitrator for the case. The office of the arbitrator is also terminated when he withdraws from the office or when the parties agree for his termination. He himself comes over and tells that I am withdrawing from office. I will not see your case. Like that he is telling. Then also the office is terminated. Then another case is the parties agree for his termination. There are two parties, both the parties agree together and tell that this arbitrator should not be there. Like that they together agree and terminate the office of the arbitrator. This is also a case where the office of the arbitrator will be terminated. If controversy regarding inability to perform, you are not able to find out whether the arbitrator can perform or not, you can go to court and file an application. The court will look at the circumstances and decide whether the arbitrator can perform or not. This will be decided by the court. If you cannot determine it, you can go to court and file an application. Now, section 15, substitution of arbitrator. The mandate shall terminate when he withdraws for the parties agreement. Same like that. When it terminates, substitute arbitrator shall be appointed. When an arbitrator is removed or the mandate or office is completed, substitute arbitrator will be appointed. Unless otherwise agreed, previous hearings may be repeated at the discretion of the arbitral tribunal. For example, one person is an arbitrator. In between, he withdraws from the office and you are appointing another substitute arbitrator. Now, any hearing which happened during the previous arbitrator, it may be repeated at the discretion of the tribunal. Now, the new arbitrator asks is that you have to conduct the hearings again because I do not know anything about this case. If he asks like that, then you have to repeat the hearings. Unless otherwise agreed, order or ruling made prior to substitution shall not be invalid merely due to substitution. For example, you can take that there is an arbitrator. He passed certain orders, order 1, order 2, all these are orders which the previous arbitrator passed. Now he withdraws from the office and another substitute is appointed. Now after the new arbitrator is appointed, whether the orders previously passed, whether they are invalid or valid. This is the question here. The law says that it is valid. It is not invalid just because a new arbitrator is appointed. The previously passed orders are valid. This is the point in this section. Let's recap what is given in section 14. The office of the arbitrator shall terminate if he is unable to perform. It is also terminated when he withdraws or the parties agree. If you are not unable to determine that whether he is able to perform or not, you can go to court and file an application. Substitution of arbitrator. The substitute arbitrator will be appointed if an office of the arbitrator terminates. Now the previous hearing may be repeated or may not be repeated. The orders made by the previous arbitrator will not be invalid merely because of the substitution. Next, section 16, jurisdiction of arbitral tribunal. Arbitral tribunal, what is the meaning of the word jurisdiction? The extent to which the tribunal can make orders. Up to this limit, the arbitral tribunal can make orders. Or there are very, very big orders which the arbitral tribunal cannot make. The tribunal does not have the power to investigate these matters. Like that, there will be certain things. This is called the jurisdiction. The extent to which an order can be passed by the arbitral tribunal. The extent to which an order can be passed. This is the arbitral tribunal jurisdiction. Arbitral tribunal is empowered to decide its own jurisdiction. The arbitral tribunal will contain lawyers and people experienced in law. They can decide their own jurisdiction. Arbitral tribunal can decide if the arbitration agreement is valid or null and void. When the arbitral tribunal is appointed, the lawyers in the tribunal can decide whether the agreement for arbitration, whether it is valid or whether it is null and void. They can decide it. Objection can be raised that the tribunal lacks power to do the adjudication of the matter. For example, there are certain matters, point 1, point 2, point 3. These three matters are the dispute which you are referring to the arbitral tribunal for arbitration. Now, arbitral tribunal passes orders on all the three matters. Now, you got a doubt and you are telling that the point 2 is there, that matter is beyond the jurisdiction of the arbitral tribunal. This is a very big matter and you cannot pass orders on this. Like that you are telling the arbitral tribunal. Now, the arbitral tribunal will take this into consideration and they will also decide whether they have jurisdiction or not. You have to give the objection as soon as the matter is raised. As soon as the matter is starting to be investigated by the arbitral tribunal, you have to tell this objection that you do not have the jurisdiction. If the tribunal deems that the matter is fit for arbitration, it can pass awards as it may deem fit. If the arbitral tribunal decides that no, I have the jurisdiction and I will pass an order, it will pass the award and it will pass the award as it may deem fit. If you do not like the award, you have to file an application under section 34 for setting aside the arbitral award. You cannot stop the arbitral tribunal, but you can make an application for setting aside the award. The next section is section 17, interim measures by arbitral tribunal. Like we saw section 9, like preservation of subject matter, appointment of receiver, appointment of guardian for unsound person. Like that, these are the measures. It is same as section 9. Section 17 also contains these measures, but these will be provided by arbitral tribunal. Under section 9, it will be given by court. This is the difference. But mainly all the contents are same. Section 18. Equal treatment of parties. The arbitrator should treat all the parties equally. Suppose there are two parties, both the parties should be treated equally. For example, if notice is given for party 1 prior to 7 days, party 2 also should be given notice prior to 7 days. You cannot give the party 2 notice for 4 days or 5 days, you cannot give. If party 1 is given 7 days, party 2 should also be given 7 days. Like this, in every aspect, equal treatment must be done for the parties. Determination of rules of procedure. Tribunal is not bound by CPC 1908, Code for Civil Procedure. The tribunal should not follow the Code for Civil Procedure. There is no compulsion for the tribunal to follow the Code for Civil Procedure, or the Indian Evidence Act also it need not follow. Then, the place and commencement of arbitration. Parties are free to decide the place of arbitration. Place in this act, wherever the word place comes, it means the seat of arbitration. The concept of seat of arbitration is explained in the previous video. The parties can decide the seat of arbitration by themselves. Upon failure of the parties, the tribunal shall decide. If the parties do not decide, then the tribunal will decide. Section 21. Commencement of proceedings. When the proceedings will commence? On the date on which the request for dispute to be referred to arbitration is received by respondent. For example, we can take that there are two parties. They got a dispute and they are going to refer it to arbitration. Party 1 is sending to party 2 a letter. In that letter, what is given is that we are having a dispute and it will be referred to arbitration. The date on which the party 2 receives the letter. This is the date on which the proceedings commenced under section 21. The next section is section 22, language of arbitration. You can decide any language which is comfortable to the parties and the arbitrator. Generally, it is in English. Section 23 to 27 talks about the procedure for arbitral proceedings. Once the proceedings started, how it will be going on, what is the procedure, like that section 23 to 27 will be discussing on that aspect. Section 23 talks about statements of claim and defense. It shall be completed within a period of 6 months from the date of arbitrator receiving the notice of appointment. Now, party 1 and party 2 will together appoint an arbitrator. The arbitrator will receive the notice of appointment, like that you are appointed for taking on the dispute and solving the case of these two parties. From this date you have to go and do the work, like that there will be a notice of appointment. From that date, within 6 months, the first part should be completed. What is the first part? Statement of claim and defense. Claim is that the problems will be given and allegations will be made on the other party. Defense is that I did not do that, like that the other party will tell. For example, party 1 is giving allegations. This is called statement of claim. And party 2 is saying that no, I did not do that. Like that it is the defense. These two are the statements given by both the parties. This statement giving should be completed within 6 months. The next section is section 24, hearings on written proceedings. Tribunal shall hear both parties and claims. The tribunal can hear oral arguments unless otherwise agreed. Tribunal can hear oral arguments. There is no restriction on that. The claims and defense submitted by the parties in step 1, it will be heard by the arbitral tribunal, and the second step. All the statements and documents given by tribunal to one party shall be communicated to the other party. For example, there are two parties. The tribunal is giving some kind of document to party 1. Now tribunal should also inform party 2 that I have given this document to party 1. Like that, the communication of documents should be coordinated very properly. For this coordination, individual arbitrators or if the individual arbitrators are appointed, party 1, party 2 and arbitrator, these three of them should make the coordination. But if you appoint an arbitral institution, the arbitral institution will make all the facilitation of documents, the communication, everything will be seen by the institution. For this reason, the administrative work is done by institution. Many of the people appoint arbitral institutions. The next section is section 25, default of party. In the same way, if one party is giving a document to tribunal, now this document party 1 has given, this should be communicated to the party 2. This is also done in the second step. Now the third step is default by party. If any party defaults in performing acts, tribunal may take action as it may deem fit. The defaults are without sufficient cause. The claimant fails to communicate the statement of claim. We saw that in the first step, the person should give statement of claim. If the person does not give the statement of claim, what the tribunal will do? Tribunal shall terminate the proceedings. The tribunal is appointed to take up the case. The claim itself, first step itself you are not giving, then what the tribunal can do? It will terminate the proceedings and stop the case. The next point is when the respondent fails to communicate the statement of defense. First party gave the claim, but the second party is not giving the defense. Now in this case, what will happen is tribunal shall continue the proceedings. The first stage is completed. The defense only it is not giving. It will be taken that the party is not giving defense and it will continue without getting the defense statement. For example, if the party fails to produce evidence or appear at an oral hearing, the tribunal gave a date for oral hearing and it told that all the parties relevant should come there. And if one party is not coming to the oral hearing, the tribunal shall pass award as per available evidence. The party would have been called to the oral hearing to provide some evidence or give some fact or give some explanation. Now, if the party did not come to oral hearing, the tribunal will carry on and proceed as per the available evidence. These are the problem. When there is a default by party, the tribunal will take the following actions. Then there is section 26, expert appointment by arbitral tribunal. For example, there is a software agreement, and in that agreement there is a dispute between two parties. In that case, they will appoint an arbitrator, and the arbitrator may not be very well knowledgeable about the software. Since it's a technical field, the lawyer will not be able to understand the software details. The party 1 and party 2 are IT companies. They can understand the software things. Now, for making it easier for the tribunal, they will appoint a software expert. He will come to the hearing and give the explanation regarding the software agreement and the technicalities. This will be done under section 26, expert appointment by arbitral tribunal. Tribunal may appoint experts to report on specific issues. Parties shall give access to necessary info and document. If the software expert comes, both the parties should give the information to the expert. Only then the expert can analyze and give his views. Section 27, court assistance in taking evidence. Tribunal may apply to court for assistance in taking evidence. For example, in some cases, the tribunal may require some evidence. This evidence may not be always available to the parties. It may be available at a bank or it may be available at a court. Like that, the evidence will be in several places. For the tribunal cannot go in each place and get the evidence. For that, the place owner will not give the permission. So we need a formal court order to go and take the evidence. Let us see an example to understand how this works. This is an example for section 27. For example, we can take that there is an owner of a house. He is giving his house on rent. There is a rent agreement and the tenant is Arjun. They both have an rent agreement and they both also have an arbitration agreement. Now, after some months, the owner comes and tells the tenant to vacate because of non-payment of rent. The owner is saying that you are not even paying rent. I am not receiving any amount from you, so you have to vacate the house or the shop, whatever the building is, you have to vacate it. Like that, the owner is saying. The tenant is saying that I have made the payment through bank and I have the bank receipt. From my account, the amount has been debited. Now I have done the payment, but so I should not vacate. I will not vacate. Like that, there is a dispute. The arbitrator is appointed and he requires evidence for payment from the bank. The Arjun is from a different bank, tenant is from a different bank, and the owner has a different bank account. Now the tenant has given his bank details that the amount has been debited, but the owner bank account, whether the amount is credited or not, that there is a confusion. So the arbitrator requires evidence of the owner's bank account details from the bank. The bank will not give the account details of the customers so easily. So we need a formal court order to obtain the evidence of bank payment from the bank. Now for this we can get court assistance to obtain the record of payment from the bank under section 27. We have to make an application under section 27 and we can get a court order for obtaining the evidence. This is the relevance of section 27 in a practical situation. Now, in the section it is given that tribunal may apply to court for assistance in taking evidence. The court will execute the order by ordering the evidence to be produced to the tribunal. The court will order to the bank that to produce the relevant documents to the tribunal. Person refusing to give evidence will be guilty of contempt of court. If the court is ordering you to give evidence but you are not giving the evidence, you will be guilty of contempt of court. You are not respecting the court's orders. This will be contempt of court. The next section is section 29, decision. Whenever the arbitration decision, it will be taken by a majority of members. For example, there are 3 arbitrators. The majority decision, the decision of 2 arbitrators will be taken into account. The one arbitrator who gave an opposite decision, it will not be taken. The majority decision will be given as an arbitral award.